90, Supreme Court 1092. Open policies, open plans, transparency, and so on, which this court has held that it is required of every, and of course it was with regards to the powers that the executive exercises. Now these are all administrative powers we are talking about. This law deals with largely, barring, of course, Section 3 was a question that was raised. I'll address it towards the end, and Section 5, which I will address separately. So insofar as public importance is concerned, this law, in fact, deals with the issues which are important for public, which is the litigants. Secondly, insofar as independence of judiciary is concerned, my lords, there is no external element, which is to say that no other institution which has given any role whatsoever under this act insofar as practice and procedure of this court is concerned. It is all confined within this court. And that alone suffices insofar as the lack of any basis to challenge this act on the basis of violation of any fundamental right, because Article 9, yes, Article 9 as expounded by this court, access to justice and of course independence of judiciary is something which is which every citizen of this country is entitled to. So my respectful submission insofar as maintainability is concerned, these petitions fail on both counts. My lord, in continuum, as far as independence of judiciary is concerned, and I take your lordships to page 6 of this paper book. Starting from Government of India Act 1935, which was the first constitutional order of this country under which Federal Court rules of 1950 were made. Under Section 214, subsection 1 of Government of India Act, the Federal Court could make rules but with the prior approval of the Governor General at that time. And in 1950, the Governor General, of course, was neither part of Parliament, there was no constitution, but under the Government of India Act, Governor General wore several hats, and the executive authority vested in him, and of course part of some legislative authority as well. Under the 1956 Constitution, Article 177 read with third schedule, Part 1, Clause 3, the rules were made with the prior approval of the President. There was not even a mention of any law as far as the 1956 Constitution is concerned. 62. Under 1962 Constitution, Article 65 said, subject to this Constitution and the law and with the prior approval of the President.
In 56 Constitution, the rule-making power was contained in third schedule.
Yes.
Had to be read with article, I forget.
What 177?
That said
subject to law and then...
No, that said subject to law. It said subject to Act of Parliament.
Act of Parliament, but I'll address that, which my Lord has just pointed out. I will address, my Lord, that question. My Lord, as far as... Just bear with me. Sir, एक second. I'll just... Article 177, I'd read it out, just for clarity. Until other provisions are made by an Act of Parliament. Third schedule would apply. And as far as 1956 Constitution is concerned, nothing happened under that Constitution, but the Constitution provision was until an Act of Parliament is made with the prior approval of the President.
56 rules were made.
Rules were made under the 56 Constitution, and Act of Parliament was not made. 56 rules came with the prior approval of the President.
Is there any
so as far as...
Is there any difference between Act of Parliament and law?
I'll address that question, my lord. This is a question that I've noted, I'll address it. Under the 1962 Constitution, Article 65, subject to the Constitution and the laws, Supreme Court could make rules with the prior approval of the President. And same position, it was same position under the interim Constitution of 1972, which is Article 193.
I'm sorry, my apologies to interrupt, but the question here is surely when Governor General is referred to and the President is referred to, that's the executive branch. The 73 Constitution had the models from going back to 1935 up to 1972. It eschewed the controlling power of the executive branch. So surely the argument there is that the framers of the Constitution expressly were trying to strengthen the independence of the judiciary, and at least, if I may use the term, eliminating one particular branch from the equation. So the argument perhaps is the reverse of what you are saying.
No, I'm coming to that.
Keep
I'm
it
coming to that.
in mind.
No, I have it in mind. I have it in mind. And when I went through this, I noticed that the executive branch was removed, but not the legislative branch. So this is the effect of 1973. This is what has happened in Article 199. The executive action was.
It's a pointer in that of the direction in which constitutional law is traveling.
I'll address that. In India, my lords, under Article 145, Clause 1, it is subject to law and with the prior approval of the President, and so is the position in Bangladesh under Article 107, identical to what is in India and what we had.
In the Constitution, these references, when they say subject to approval of the President, is it unilateral discretion of the President, or it is President advised by the Chief Executive, albeit the Prime Minister, whoever that is?
My lord, so if we look at the jurisdictions where we have this position, of course in India, he acts on the advice. And if, for example, under Article 191...
Government has the last say, not Parliament.
Yes. It was, no, my lord,
with
the
distinction.
prior approval.
The prior approval of the President means effectively prior approval of the Prime Minister, not the legislature.
Yes.
Okay.
You said that in the Indian Constitution also it says subject to law, but that provision doesn't read like that. It's subject to the provisions of the law made by Parliament.
Yes.
So it's not subject to law.
I will come to that when I take you to Article 191. I'll come to that. I'll come to that when I take you to 191.
I'm just clarifying जो आपने argument की.
My lord.
वहाँ ये नहीं लिखा.
जी when I'll address subject to law, I'll be addressing.
Page 7 pe you reproduce.
Page 6 and 7, yes, my lord. Now, in other jurisdictions, in United States, for example, this is 28 U.S. Code, Chapter 131, Section 2071. The rules made by the Supreme Court have to be consistent with the acts of Congress. And the latest development, or later development, is the Constitution Reform Act of 2005 of the United Kingdom. Now, under Section 45 of that act, the President of the US Supreme Court makes the rules, but is required to consult with the Lord Chancellor and all the bar councils while making the rules of procedure. So this is the progression, or this is how this is the system that we have in place.
2000 UK Act, does that
2005.
2005 UK Act, for example, do the rules have to be placed before the Houses of Parliament, or is there any involvement at all by the legislative branch?
There is none, but
he has to consult.
He has to consult. Now, whether
other than the Lord Chancellor, who is a dying breed in the sadly in the UK system, but anyway, Parliament has made the law despite their rule of sovereign legislative supremacy. The Parliament itself has said it's got to be totally independent of us.
Yes. And for that, now, I take your lordship to Article 191. Now, this is where I will address what the term law means and what is the scope that this term has, and whether an act of parliament would be actually covered under the term law or not, or whether we can give it a meaning where an act of parliament would be excluded from the definition of law and everything else would come under the.
Why? I don't even understand this debate. Why is this? What is I couldn't understand the point of counsel. What was he saying really?
My lord, the counsel was arguing, began by referring to clause 1 of Article 8, where it said that any law or custom or using having force of law, etc., shall not be made. And then clause 2 said that places a limitation, embargo on the state to not make any law which is inconsistent with the provisions of this, with the chapter.
This differentiation between an act of parliament and law, what is the significance here?
My lord,
I missed the point. I tried to.
In my respectful submission, there would be none as far as Article 191
But
is concerned.
you were started by arguing on maintainability. Let's finish your argument. You're now addressing his arguments.
Gee, now what I'm on insofar as maintainability is concerned, my lord, my submissions are that this law actually addresses the public concern. It addresses the issue of public importance by bringing in transparency and by structuring the discretion and by democratizing this institution, by and transparency, by conferring powers, or by, let's say, devolving powers.
Mr. Attorney General, so both sides agree that a question of public importance is addressed in this. The only question is now whether a fundamental right has been violated,
Yes.
and if a fundamental right has been violated, which fundamental right?
Correct.
Because question of public importance तो आप भी concede कर रहे हैं या कह रहे हैं कि है, इसमें आप उसको मुख्तलिफ तरीके से point कर रहे हैं. आप कह रहे हैं जी public importance question है जिसमें हमने address किया. The other side doesn't agree, but the common denominator is there is a question of public importance.
I think my lord is correct. To that extent, you are in agreement. Now, the other limb of the argument, I mean, public importance is, in my opinion, a variable. The other importance is enforcement of fundamental rights. And other than that, I think the general, how the law is developed, a law is sustainable unless otherwise proved. So the burden is on the person who challenges a law to say what has been done. If he's invoked Article 199, his jurisdiction is far wider of the high courts. You can attack income tax law, any other law in Pakistan for whatever reason you can, not limited to enforcement of fundamental rights. Attack under 184(3), leaving aside the public importance, and I think you both are probably agreement there, is a narrower attack. So the person has to come within attack on a fundamental right. What is the fundamental right that has been violated? Absolutely. Your arguments, what I could understand from is, rather than violating a fundamental right, this is a beneficial legislation for the litigant, not for me, not for the state. Everyone may benefit by it or none may benefit by it, but there's certainly, you're not taking away anything, that you are stopping a right of appeal, you're giving a right of appeal. Whether that can be done, that's another argument, constitutional plane. Whether that could be addressed in 184(3) or under 199, it's an argument. I'm seeing myself sitting in original. Otherwise, every case will just be filed in the Supreme Court. Don't bother about the High Courts at all. If you read with the jurisdiction of 184, can we just read it for my own benefit, because we tend to forget certain words of 184(3). We don't have additional powers, we have lesser powers in the High Courts.
Clause 3, my lord.
Pura padhe.
Ji.
One the government wala hai na?
Should I read 1 and 2 as well? Yeah, 3 pad do.
3 pad.
3 pad. Without prejudice to the provisions of Article 199, the Supreme Court shall if it considers that a question of public importance with reference to the enforcement of any of the fundamental rights conferred by Chapter 1 of Part 2 is involved, have the power to make an order of the nature mentioned in the said article.
In other words, which is the said article 199. So the High Court, you don't have to go for a public importance matter. You don't have to go for enforcement of fundamental rights. You can still go to the High Court. Here, we don't have extra powers. We have the same powers as the High Court, but we have two restrictions: public importance and enforcement of fundamental rights. Public importance is variable. Let's stick to fundamental rights. So the power here is not a much larger power. So my reading of the Constitution, a much narrower power than the High Court. High Court may strike down this law, arguably, and then we can sit in 184 as an appeal. Then we have more powers. I don't know, am I wrong in my understanding?
That's correct, my lord. And my lord, as far as challenge to the vires of this law.
Just to add to that, where a law deals with powers of this court, the Supreme Court of Pakistan, do you think it would be appropriate for the High Court to adjudicate upon it?
My lord, in another proceedings, this is a submission that I had made in other judgment where a specific question was raised, and my submission, respectful submission at that time was that yes, and I maintain that position.
But are you aware there is a judgment of this court which says otherwise?
My lord, now I'm before a full court, so I'd just, based on that, I'd just proceed. My lord.
I know you pressed for time.
Attorney General, can you explain the word enforcement? It's not the infringement of the fundamental right. It's the enforcement of the fundamental right. So,
public importance with reference to the enforcement. With reference to the enforcement.
Here, fundamental, public importance, fine. Both parties are there. Now, had it been infringement, then you were right that there has to be a right which was infringed. Here, it's more wider. It's enforcement. So they are saying that this is a matter which relates to access to justice. So it's an enforcement of that particular right that they're talking about. They're not saying that it's an infringement of the fundamental right. Can you explain? Can you expound on that?
My lord. Now, of course, as I said, my lord, I reiterate that yes, access to justice is a right recognized by this court covered under Article 9, and to that extent, yes, it would be a fundamental right. Now, what they had to show was, the burden is on them, while challenging the constitutionality of this act on the basis of lack of enforcement of fundamental right, as my lord has just pointed out, not infringement of right. What they have to show is that this law does not, in fact, enforce this right of access to justice.
No. It's first we are at the threshold of the maintainability. We don't go into whether this law is right, whether it is wrong, whether it is enforcement of the fundamental right or it is an infringement. As far as maintainability is concerned, public importance is done. Then we come to this issue of, does the petition that they have filed, does the petition talk about enforcement of the fundamental right or not?
The petitioner, my lord, proceeds on the basis that by way of this act, powers conferred upon the Chief Justice under the Supreme Court rules have been curtailed or taken away, and that then results in this law being unconstitutional. It is not the case here that this act in any way prevents enforcement of any right.
Attorney General, one way of looking at it is the enforcement part, that whatever act has been challenged impedes the actualization of the fundamental rights. So perhaps it's interchangeably talking about infringement, however uses a different word. So if a citizen comes and says this particular act thwarts or impairs the actualization of my fundamental right, I'm coming to the court. So enforcement or infringement might be synonymous. One more thing, I think the question of public importance also is a threshold entry point. Suppose if we see, don't you think the petitioner will have to show that in order for it to be a question of public importance, there must be apparently that law must be against public interest. But suppose if it's clearly in favor of public interest, does it constitute a question of public interest? To become a question of public interest, it must apparently prima facie be something against public interest, and then you say, yes, it's a question. But if it's so obvious that the whole law is in public interest, for example, do you think there's a threshold to that effect, or there isn't any?
My first part of my submission, my lord, was that the question of public importance, on public importance, my lord, when I pointed out that what this law does is it democratizes this institution, brings more transparency, structures the discretion, it actually advances that public interest. And therefore, they fail on that threshold, that count as well.
Attorney General,
my lord.
on my repeated questions, in response to my repeated questions, they conceded very explicitly that this is a good law. It enhances access to justice, and also, speaking for myself, it addresses a very, very big issue of internal and institutional independence. Now, in that context, when this is an admitted fact, the only question whether the parliament had the competence or not, क्या जो 184(3) की requirements हैं, वो fulfill होती हैं, because there is no enforcement of fundamental rights.
My lord, if that is so, then these petitions have to be rejected on this basis alone, because insofar as legislative competence is concerned, 184(3) cannot be pressed into service.
So taking
If we'll let you, I think a lot of questions are coming up. We'll note. I'll try to make a point.
These are, my lord, please.
Well, अगर आप थोड़ा सा अपना continue रखें, I want to know where you're going. Okay.
Attorney General, if I may ask you a question, is it in the public interest that Parliament, or for that matter a provincial assembly, remains within the limitations that may be placed by the Constitution on Parliament or a provincial assembly? Is it in the public interest?
My lord, which fundamental right would it
I'm not
be
talking of
affected?
fundamental right. I'm talking of public interest.
Of course.
Of course.
Yes.
So therefore, if a law...
Again, this is happening, which I must, sorry, interject. I would, you have agreed, now here I won't agree with you. I will say it may be unconstitutional, but not within the parameters of 184(3). There may be a lot of unconstitutional things going on in Pakistan, but it won't come within the parameters of 184(3). That is the fundamental point. That's my way of approaching it. Others have different ways of approaching it. So I think आप जरा चलें, फिर आप note कर लें सवाल.
I just, this part I just
General, if I may continue, sorry, if I may continue. It is in the public interest. I'm not speaking of any fundamental right. I'm only speaking of public interest. It is in the public interest you accept, and I think rightly so, that because we have a federal structure, Parliament and provincial assemblies must remain within constitutional limits, right? Whatever those constitutional limits are. So therefore, it seems to me to follow logically that if Parliament makes a law that is ultra vires, or a provincial assembly makes a law that is ultra vires, it is in the public interest to challenge that law. Because if remaining within the constitutional limits is in the public interest, then going beyond those limits and making an ultra vires law is surely a breach of public interest. What would you say to that?
That touches upon the legislative competence.
No, I'm talking of public interest.
Yes, but,
Yes,
but
is it
any
in the-
law, a law
is
cannot
it
be
in the
struck
public
down on the
interest?
basis of just
Where,
being public.
where the challenge can be is a separate.
My lord, let's just take a step back. Any law made by any legislature, provincial assemblies or the parliament, would be a matter of public interest and importance. It is a law which is being enacted. Now, in order to examine that law, in order to assume jurisdiction to examine that law, we have to look at, in the case of Supreme Court, Article 184, and the cases of High Court in 199.
नहीं, आप
Now,
देखिए, आप तो कह रहे हैं ना, मैंने जो नोट किया, हो सकता है मैंने फिर गलत नोट किया हो, आप तो कह रहे हैं कि this challenge fails on both counts.
Yes.
Public interest and this.
जी.
तो मैं अभी सिर्फ public interest पे देख रहा हूँ ना.
But
तो मैं आपसे पूछ रहा हूँ, I mean, speaking for myself, it seems to me that any law which is ultra vires, whether by parliament, whether by provincial assembly, meaning breaches the limitations, whatever they may be, imposed by the Constitution, because the Constitution is supreme. It is it is contrary to public interest. Has to be.
Now, let me just quickly address this, because this is a maintainability issue here, and I want to address that issue here first and foremost. The two conditions provided under Clause 3 or required under Clause 3 are connected. It has to be a matter of public importance with reference to enforcement of fundamental rights. Now, independently, any legislation, any statute, any rule or any regulation would be a matter of public importance or public interest for that matter. Now, in order for this court to assume jurisdiction, now this court does not assume jurisdiction under 184.3 on a legislature, on any law being enacted for want of legislative competence. It has to be ultra vires or violative of the rights, fundamental rights granted.
So you say that the word relating to enforcement.
With reference to the enforcement of.
That you say is the buckle that connects the two things.
That is the buckle that connects the two, and that is where it actually prevents, if I may say so, this court to examine constitutionality of a statute on legislative competence.
Is legislative competence not in the public interest?
As I said, Your Ladyship, this is something, legislative competence alone is something which can only be examined under 190.
Is it not a right that everyone has under the Constitution
My Lord,
that laws are made in a particular way?
Legislative competence, of course, as I understand it, what you have to see in the act is an act of parliament, whether Article 70 read with the list permitted it or not, or whether there is a provision of the Constitution which directly confers that power upon the parliament, whether that provision permits it or not. And if those provisions do not permit that legislature to legislate on that particular matter, then yes, this is a legislative competence issue, and it is not permissible under 184.3
so
to touch.
In your opinion, the law is good law, Parliament is competent to make the law, and every provision of the law is valid and does not in any way violate any provision of the Constitution. So then what happens again? I go back to the full court hearing aid, and you are given a right of appeal under that. So are they not then entitled to their right of appeal in the event that the court decides that these petitions are not maintainable? They cannot challenge it? And does that not go to the fact that once again you've put the burden on the court itself to decide when it wants to constitute a full court and block that right of appeal, and when it wants to constitute a smaller bench and allow that right of appeal?
And whether the act is in field or is suspended.
I think my illustrious colleague has raised a very valid point, and I was thinking about it during the break. If we read the right of appeal, first of all, it talks about an aggrieved person. Now, I'm trying to envisage a scenario where one would be aggrieved. First scenario. Second thing is, we can, and this is permissible, read down legislation. We can, for instance, read into it that wherever there is a full court, needless to say, you cannot have a right of appeal over the full court, so that one can read down the legislation that those cases. But which right have we determined? What have we taken away from someone? Someone gets an extra right to challenge a judgment, if at all it's an irritation to us. Oh, now you have to have the appeal. Oh, now the review jurisdiction has been extended. So what are we doing? And it's not conferring this power to an executive functionary, to the legislature, to the president, or to anybody else. It may be nuisance value for us. Our reviews are going, our appeals are going, that sort of thing. What are we taking away? If the judgment is correct and in order, should we shy away from looking at it because someone files an appeal? Yes, it may bring in litigation into the court. That's the downside, may be said. But where is the aggrieved person? Who will be the aggrieved person be? The person affected. Because I think the 184.3, the whole intendment of that was for not for lawyers. It was not for the well-to-do. It was not for the multinationals. It was for the poor, the dejected of society. We have a whole chapter on the principles of policy, which no one bothers to, we don't read. Bonded laborers, transgender, women rights, children, they can't come to court. We can intervene, 184.3 can come to their rescue. So I was looking at things in that perspective. We have to see the whole entire constitution as a whole. We just stuck with one provision that somebody says, hey, please tell me how you aggrieved. I kept asking him, are you aggrieved? He says, no, they couldn't do it, you can do it. That's about the argument that I've understood so far. That's a valid argument on its own. Yes, to be addressed, for instance, the income tax ordinance has certain provisions that have been challenged before the High Court. Could we entertain it in 184.3? After all, it is a legislation. After all, it's a public interest. After all, it's a taxation matter. It will meet all the tests of public interest. But it is not, because taxation is not a fundamental right. You can't tax or not tax or whatever. Nobody can say my right not to be taxed has been infringed. So go through the High Court route, get a 191 petition, come to the Supreme Court in 184. That is appellate jurisdiction. So we should read the Constitution and not just pick the words. We are just stuck with these words, 2 words also. Who's harmed by this? The only thing is you've taken away our power. You've taken away specifically the power of the Chief Justice. That's one irritant. You've given a right. That's another irritant. You have created another same lawyer. Okay, person wants to waste money on another lawyer, do so. So his pocket will be lighter. What is it to us?
Mr. If I may, take you back to what you were saying about, and I understand your point, relating to the buckle part of it. So here we have a law which relates to the practice and procedure of the court, and that is, you say you accept that any law which is ultra vires is against the public interest, but you say the buckle is missing because it doesn't. It has to. It's not just legislative competence alone, but it has to relate to fundamental rights. So I was just wondering.
If I may rephrase it before my Lord formulates the question. Legislative competence cannot be interfered with here.
No, I'm just saying, I understand that. So he may care on.
Yes.
But breach of legislative competence contrary to the public interest. Until it is related to fundamental right, 184.3 cannot be invoked. This is your argument. So I was just wondering that the subject matter of this law essentially is the practice and procedure of the Supreme Court. Article 10A relates to due process. So surely any law relating to the practice and procedure of any court, but let's take the Supreme Court, which is ultra vires, surely that affects due process and therefore is directly relatable to a fundamental right. What would you say to that?
And that is where, when passing this threshold, of course, when a petition comes before your Lordship, so before this court under 184.3, these are the 2 things which are to be examined at first instance. Now, once this threshold is met, then, and the burden is just discharged.
Article 10A. It helps sometimes to refresh our memories.
For the determination of his civil rights.
Of his civil right, not the Supreme Court civil rights. Aage padhe.
And obligations, or in any criminal charge against him, a person shall be entitled to a fair trial and due process.
It's nothing to do with the Supreme Court's due process. It's his. Have your right of appeal been taken away? Have your right of cross-examination been taken away? Have your right of a statement under 340 been taken away?
So that's where then it takes me, my Lord, and I just addressing your question.
Mr. Attorney General, the subject matter is legislative competence in relation to practice and procedure. Surely as a matter of principle, it's not a question of whether the law is taking away. It is this due process in and of itself? And if the law is ultra vires, the answer is precisely because it is ultra vires, it can't be due process.
So let's proceeding on this.
Whatever it says, whether it says
I'll go with it.
Chief Justice is master of the roster or five.
I'll go with it, and let me just make my submission on this. I'll go with it. When somebody brings in, and let's assume, for the sake of argument, let's assume, and for a moment, if it is assumed that yes, it is a matter with reference to fundamental rights as well, then what has to be shown in the first instance is that this legislation fails to enforce or infringes any of the fundamental rights that the citizens may have.
Well, if due process is interfered with, surely
they have not shown anything to say that there is any due process. which they are entitled to under the existing scheme or the scheme as it stood prior to this act has been
We
effective.
made questions. You can continue.
Well,
I think we have our own views or opinions. आप चलें आगे.
My lord. Now,
You have to persuade us, not we have to persuade you.
Just one question I was just thinking about it. Suppose a provincial assembly or even the parliament tomorrow makes a law saying after an appeal has been dismissed under Article 185, another appeal would be available to the litigant before a larger bench. Would that law stand?
I would rather consider these.
Competence की बात कर रहा हूं.
Let's consider what this law did. Maybe tomorrow that very matter comes before us.
So the question is.
a second
the
appeal.
question
My
is-
lord's question is whether the second
no,
appeal would
no,
be
not
provided.
at all. I am questioning the competence. The appeal in the Supreme Court under 185 is provided by the Constitution. Can another appeal, which is not specifically provided in the Constitution, can be provided by ordinary legislation? The example I gave you was an extreme example. The first question is, can by ordinary legislation an appeal be provided where the Constitution specifically does not against orders passed by the Supreme Court?
I will add to this question. Is there any
और
provision
वो
in the
उसमें
Constitution
उसको
preventing
जो वो टेस्ट है कि जी वो आइटम 55 का कि जी वो हमने तो इनलार्ज किया, पहले एक अपील थी अब हमने दूसरी कर दी है, तो इसलिए ये हमारी कॉम्पिटेंस में है. Would that argument stand?
Noted, my lord.
ये
आप बाद में जवाब दे दें, आगे बढ़ते हैं.
ऐड कर रहा हूँ इसमें दूसरी तरीके से. Is there any provision in the Constitution preventing the Parliament from doing so?
Noted, my lord. Now, my lord, if my lord may kindly turn to Article 191. Let's go to Article 191. It has been read out. I'll just read the first part of it, where it says, subject to the Constitution and the law.
Mr. Attorney General,
My lord.
please you read just the preamble of this act and section 3.
Yes. Yes, my lord, it has been read out.
Talks about Article 10A.
Article?
10A.
Yes, it does.
Specifically. And Article 4, Article 25.
My lord.
And subsequently in section 3, specifically talks about 184.3.
My lord.
How this can
It does-
be
it does not-
proceeded
was 3,
under
yes.
Article 199 when specifically it is challenging the mandate of the Supreme Court as per section 3 of this act.
My lord.
And how that can be moved before the Supreme High Court under Article 199 of the Constitution.
My lord, I noted. My lord, now the question that has come before your lordship is whether this Act, 2023 Act, is covered under the definition of law, howsoever expansive definition, however expansively the term law is defined. My lord, Article 260 has two definitions. One is of an act of parliament and the other is of a federal law. Here we are dealing with the federal law. Article 260 defines the federal law. It says,
You say over here, law includes statute law.
yes,
Point.
yes. In my respectful submission, law can only have one meaning as far as this provision is concerned. But even if it is given an expansive meaning, this act would surely be covered under the definition of law.
It's to be covered, then why didn't the Constitution say by an act of Parliament? Why did it use the word law? These words are not interchangeable. They are used in a very specific sense in different articles. And so you have to, the interpretation has to be given to the word law and not to just say, just because law includes legislation. So here it will be legislation alone. Law has a meaning, and if the Constitution wanted to say just by an act of Parliament, it would have used those words.
Your Ladyship, when we look at the provisions from where the Parliament draws its
Why did you
legislative
look at 75.3?
जी 75.3 and 141 and 142 as well.
पढ़ लेते हैं जरा उसमें दोनों लफ्ज इस्तेमाल हो गए.
When the President has assented or is deemed to have assented to a bill, it shall become law and be called an act of Majlis-e-Shura.
So law is what happens. What it is, the name of the thing is, you are a man. Your name is Mansoor Rahman. I would read it like that.
And the definition of federal law under Article 260 is, federal law means a law made by or under the authority of Majlis-e-Shura Parliament. Now, if we turn to Article 8.2, for the sake of this submission, where any law which is inconsistent with fundamental rights is void, Article 8.2 says, the state shall not make any law. Now, the state is not just the Parliament, the state is the province, the governments and the assemblies and any authority which has the power or is authorized by law to impose any tax or cess.
आप फरमा रहे हैं कि law, and you refer to the definition of federal law. It doesn't say federal law, it says...
It does not. What I'm saying is...
I have a question for you. Suppose a provincial assembly under Article 191 law बना देती है, बना सकती है?
So 2000 के अंदर 2000 Supreme Court deals with that question. Yes, they cannot. The answer, because the power with respect to legislation with respect to regulating the court's jurisdictions or powers flows from entry 55. So 191 or 175(2) for that matter.
Respect, I draw your attention to entry 58.
Relates to the federation also. Yes.
Kindly read it.
Matters which under the Constitution are within the legislative competence of Parliament or relate to the Federation.
So therefore it seems to me, and I put it to you as a question, that actually entry 55 has nothing to do with Article 191. The power that is specifically conferred on Parliament to make statute law, and in terms of Article 191, is relatable to entry 58. Entry 55 has got nothing to do with Article 191. And this connection, first of all, excludes the example that I gave of a provincial assembly making a law over here, right? And secondly, it establishes that here there is a direct grant by the by a specific article of the Constitution on Parliament, as opposed to the general grant as conferred by Articles 141, 142 and so on. That's a general grant. This is a specific grant. Because precisely it is a specific grant, it relates to a specific entry 58. So I would put it to you as a question that entry 51 has no relevance for the present issue.
Entry
55.
Has no relevance. This is a matter between, insofar as law is concerned, statute law, Act of Parliament, the connection is 191 and entry 58. I would say to you, entry 55 has got nothing to do with it. What would you say to that? Keep it in mind and move on.
Well, now, my lord, if my lords may kindly turn to Article 141. This is with respect to reference to the use of term law in Article 191.
Should be read with Article 260.
260.
Act of Parliament. So here is the word is law, so you can read together.
And 141 and 142 also is in continuum, my lord. 141. Subject to the Constitution, Parliament...
सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट 2023 के खिलाफ दरखास्तों पर समाअत। चीफ जस्टिस काजी फायज ईसा की सरबराही में फुल कोर्ट समाअत कर रहा है। तारीख में पहली मर्तबा फुल कोर्ट की समाअत पीटीवी न्यूज और पीटीवी नेशनल पर बराह रास्त नशर।
We entertain it in 184.3. After all, it is a legislation. After all, it's a public interest. After all, it's a taxation matter. It will meet all the tests of public interest. But it is not, because taxation is not a fundamental right. You can't tax or not tax or whatever. Nobody can say my right not to be taxed has been infringed. So go through the High Court route, get a 191 petition, come to the Supreme Court in 184. That is appellate jurisdiction. So we should read the Constitution and not just pick the words. We are just stuck with these words, 2 words also. Who's harmed by this? The only thing is you've taken away our power. You've taken away specifically the power of the Chief Justice. That's one irritant. You've given a right. That's another irritant. You have created another. Same lawyer, okay, person wants to waste money on another lawyer, do so. So his pocket will be lighter. What is it to us?
Mr. If I may, sorry, here, take you back to what you were saying about, and I understand your point, relating to the buckle part of it. So here we have a law which relates to the practice and procedure of the court, and that is, you say, you accept that any law which is ultra vires is against the public interest, but you say the buckle is missing, is against the public interest, but you say the buckle is missing because it doesn't, it has to, it's not just legislative competence alone, but it has to relate to fundamental rights. So I was just wondering.
If I may rephrase it before my Lord formulates the question. Legislative competence cannot be interfered with here.
No, I'm just saying, I understand that. So he may care on.
Yes.
But breach of legislative competence contrary to the public interest. Until it is related to fundamental right, 184.3 cannot be invoked. This is your argument. So I was just wondering that the subject matter of this law essentially is the practice and procedure of the Supreme Court. Article 10A relates to due process. So surely any law relating to the practice and procedure of any court, but let's take the Supreme Court, which is ultra vires, surely that affects due process and therefore is directly relatable to a fundamental right. What would you say to that?
And that is where, when passing this threshold, of course, when a petition comes before your Lordship, so before this court under 184.3, these are the 2 things which are to be examined at first instance. Now, once this threshold is met, then, and the burden is just discharged.
Article 10A. It helps sometimes to refresh our memories.
For the determination of his civil rights.
Of his civil right, not the Supreme Court civil rights.
And obligations, or in any criminal charge against him, a person shall be entitled to a fair trial and due process.
It's nothing to do with the Supreme Court's due process. It's his. Have your right of appeal been taken away? Your right of cross-examination been taken away? Have your right of a statement under 340 been taken away?
So that's where then it takes me, my Lord, and I just addressing your question.
Attorney General, the subject matter is legislative competence in relation to practice and procedure. Surely as a matter of principle, it's not a question of whether the law is taking away. It is this due process in and of itself? And if the law is ultra vires, the answer is precisely because it is ultra vires, it can't be due process.
So let's, proceeding on this.
Whatever it says.
Judgment cannot be overruled unless the basis or the foundation on which that judgment came about is altered or removed, which is to say, if the underlying law is amended, then the effect of that judgment goes away. And that is where, even if, for the sake of argument, the term law includes a judgment, if the rules which were expounded by your Lordship in that judgment.
First of all, I didn't say judgment, I said case law. Judge-made law is different from judgment. That is precedent.
So learned counsel.
And also, आप जो अभी बात कर रहे हैं, extrapolating from that, is the rule surely an interpretation of the Constitution or the establishment of a rule of constitutional law by the Supreme Court surely cannot be affected by Act of Parliament. It can only be if the Constitution is amended or the court itself changes its view. Classic example, right of abortion. added to the Constitution Roe versus Wade by the US Supreme Court, taken away as egregiously wrong by in Dobbs versus something or another 2022. I think surely that is settled constitutional law.
My lord,
please, if you don't mind,
I have to take your lordship.
Please proceed further. I mean, we will write a judgment, whatever we want to write.
Now, my lord, I will. My learned colleague will be recording the questions, noting down the questions, and I'll respond.
One thing, how I understand this. This is not my statement.
Rahman knows shorthand.
This is not my statement. This is my understanding. The Act of Parliament can be considered as law as well. But every law cannot be considered as act of the parliament. जैसे कि आप मिसाल लेते हैं, landlord can be landlord, but owner can be treated as owner as well as landlord. तो इस तरीके से ये जो legislation है, तो parliament करती है, उसको आप law भी कह सकते हैं, act of parliament भी कह सकते हैं, लेकिन जो judgment या case laws से आते हैं या customary law होते हैं, उसको आप act of parliament नहीं कह सकते, तो इसलिए उसको confine किया गया, law किया गया.
कह भी नहीं सकते, my lord. और दूसरा एक और just let's look at it from another aspect. Now, 1980 is when these rules were made, and when these rules were made, if I draw your attention to Order 11, Order 11 को जरा देखिए.
अगर हम बहुत ही pedantic approach ले लें,
Order 11, my lord.
ये pedantic approach ले लें, ये rules किसने बनाए? किसने बनाए?
Supreme Court ने. कब? 1980.
Supreme Court क्या होती है? नहीं, hang on. If you go into that approach, Supreme Court क्या होती है? बताइए.
All the Chief Justice and the judges
sitting at home. No way. No, but if you're going to go that route, then you can even say these are what is they say Supreme Court can make, not administrative meeting of the judges of the Supreme Court. Where does the Constitution provide for an administrative meeting of the judges of the court? So we don't want to just destroy the entire system of governance. So did we sit in a court of law? Did we pass a judgment? How did these rules get enacted? Did people have a say in the matter? Or 10, 15, 17 people, then all gentlemen got together in a closed room and say, here, where is the concept of an administrative thing? That administrative concept itself is created by the rules. So surely it cannot supplant the Constitution itself. It says the Supreme Court. It's very clear. Now, I'm not really understanding. I am only concerned with one and only one thing. What have we taken away from Khwaja Sahab, his client, or any citizen of Pakistan? What have we taken away? What have you taken away? If you've taken away something, we will strike it down. I mean, I don't know why we are having this academic discussion. I really don't understand the point.
My lord, if I may. Now, there is this provision under this law, and Section 7, for example, application for fixation of urgent matters. Do we not know that there are people who died in prisons, condemned to death before their appeals came up for hearing?
This is our domestic affair. We can
No, with great respect, my lord, it is not.
It is.
Absolutely not, my lord, with great respect. This is the right of the citizen, litigants ka right hai. My lord, with great respect, it is not.
Resolve this.
It can't possibly be.
Learned Attorney General, what if the Chief Justice refuses to call a meeting of the full court and refuses the full court to amend the rules? Should the Parliament not intervene in the interest of the litigants? That is exactly what has happened.
And here, if my lords may kindly turn to Order 11 of the Supreme Court rules. Order 11 of the Supreme Court rules. I'm just going to take this point forward. Order 11 of the Supreme Court rules. It begins by saying, save as otherwise provided by law. The full court, going by, let's say,
एक मैं आपको इसमें तसादुम दिखा दूं अब मौजूदा रूल्स में जो आइन से तसादुम रखती है, ठीक है? Appeal is a right. Civil petition for leave to appeal is not a right. For an appeal, the rules provide 30 days, which is a right. For a civil petition for leave to appeal, you get lots of time, 60 days. I would say it violates the very concept of the Constitution. Maybe it's a mistake, but the other question would be, suppose can these rules be challenged? I think they can be challenged. If they had a supra-constitutional effect, they can't be challenged. Suppose I refuse to suppose tomorrow I refuse to fix any bench, what will compel me? At the moment there is a stay order of provision, I said, nahin, hum chutti pe jaate hain, court hi nahi lagate hain. What will you do? Move a reference against me, that's about all. You can't compel me under any law to do that. So the object is, there has been a problem, there has been successive addition of cases, we are completely closing our eyes to it. हम 2019 में full court meeting हुई थी, वो भी हम नहीं कॉल कर सकते, वो भी इख्तियार चीफ जस्टिस का है। 2019 से 4 साल गुजर गए हैं, क्यों नहीं मीटिंग कॉल हो रही है? 2019 से उस जमाने में 40,000 केसेस थे, अब उसमें ऐड हो गए 27,000। हमारी मर्जी, हमारा डोमेस्टिक अफेयर है? नहीं, हमारा डोमेस्टिक अफेयर है, पर हम तनख्वाह नहीं लें स्टेट से। हम जब टैक्स पेयर हमें पैसे देता है, हमें काम के लिए पैसे देता है, केस का फैसला करो, ये हमारा काम है और कोई काम नहीं है, बाकी सारे हमारे पेरिफेरल काम है। तो ये आप इतने आप उस मेन पॉइंट पे आप नहीं रह रहे हैं, आप भी खिसक रहे हैं उधर, वो भी मेन पॉइंट पे नहीं आ रहे हैं।
My lord, I just rephrase
Constitution of benches का,
जी,
इसको पढ़े ना, ये save as otherwise provided by law।
जी, so
तब तो कोई लॉ था नहीं
जी, उस वक्त नहीं था, बट ये रिकग्निशन थी कि लॉ प्रोवाइड कर सकता है कुछ।
नहीं, आपसे ये अभी देखिए,
उस वक्त लॉ नहीं था।
अब ये लॉ, क्या ये आपके ख्याल में ये जो 1980 के रूल्स हैं, ये लॉ है?
My lord, these are
आपसे simple, are the 1980 rules law, come within the purview of law or not?
191 की definition क्या आप
Article 191?
No, sir.
No.
But these are the rules।
These are the rules. The language says subject to the Constitution and the law, the Supreme Court will make rules.
What is the purpose of mentioning save as otherwise provided by law?
Yes, this is the recognition of what Article 191 provided. Now, at that time, there was no statute or an act of parliament which provided for anything, but the full court of this court left it open.
Now the law has been promulgated, and this covers under this provision.
Yes, not just this provision, it is covered under 191. This only recognizes what 191 already provides.
Mr. Attorney General, then you are excluding all those laws which are made under the delegated powers. You are excluding all those laws which are made under the delegation of the power by the government or the parliament. Delegated legislation.
In what context, my lord?
In the context of definition of law. There are two primary law and the delegated law. And delegated law includes the rules.
No, we are looking at it.
The Supreme Court rules are not law.
We are only looking at the language of 191. We are looking at the language of 199, and we are trying to understand what is the term or what is the scope of term law as provided under 191 is.
Yes.
Now, I had taken your lordship through how this provision or the pari materia provision had historically progressed, where in addition to parliament there was a role of executive as well. That role was taken away, that role was eliminated, but the role of parliament remained. And, my lords, Article 67, which provides for the regulation of the rules of procedure of the houses, there is no such
You have not
language.
You have not argued on Article 142, because this is the distribution of legislative powers.
Yes.
And Majlis-e-Shura Parliament shall have exclusive powers to make laws
with respect
to any matter in the federal legislative list.
Yes.
And if we go through Article 50, the legislative list, item 57, it is also related to
58.
58. उसके साथ 55, sorry, 55
yes,
jurisdiction and power of all courts.
So insofar as Section 5 is concerned, it is entry 55. With respect to other provisions, it is Article 191 read with entry 58.
Article 50,
Is
sorry, item 58.
it not coming under 55? It says enlargement of the jurisdiction of the Supreme
That's
Court
what I said, sir.
and the conferring up thereon of supplemental powers. So it has given us more powers. I have committed a mistake. I've given you an exact example of a Himalayan mistake committed by this court, the Recodic judgment. 6.5 billion. Isn't that a big enough mistake for us to understand?
That's exactly what I've submitted. Section 5 is covered under entry 50.
So you are trying to resolve that. Why? I don't know. I mean, they don't argue the case. I don't know why we're not proceeding. We love quoting American precedents. Why don't we quote the American precedent, which the Supreme Court of America says 20 minutes and nothing more?
My lord.
You are not, please don't take questions, you just hear them, write them down, whatever.
Now, my lord, I just stick to the submission that I had made in the beginning. Mr. Amir Rahman is the person who is recording the question.
Attorney General.
अब आप देखिए हम आज से सुबह से कोई 150 cases की addition हो गई होगी because of this case. We can hear this case for the next month. No other work will happen in the Supreme Court. If you want the system to collapse, please proceed. Take your time. We won't interrupt. ख्वाजा साहब नाराज हो कहते हैं, अब आप नाराज हो जाएंगे, मुझे बोलने दे रहे हैं. पॉइंट्स ले हम नोट करेंगे, हम आपको सुनने के लिए बैठे हैं, आपने इतनी मोटी चीजें दी, हम पढ़ लेंगे इनको.
Now I just quickly rush through my submissions and
my question that in order 11, the use of the word law, the term law, you think it carries the same meaning as in Article 191?
Yes.
Thank you.
Now, my lord, if leaving this act out of Article 191 would render part of Article 191 redundant where it says subject to law. And redundancy cannot be attributed lightly to a statute, let alone a constitutional provision. The judgments are in the paper book. My lord, there was another submission which was made with regards to field being occupied, which is to say that since the rules had been made, therefore the field stood occupied and therefore a law cannot be made. Now, that principle also does not apply because that principle is only applicable where the powers are coextensive or coterminous. Here, the Constitution specifically says that the rules shall be subject to the Constitution and the law. It can't be. So therefore, the principle of the doctrine of occupied field does not get attracted here. Now, my lord, if I may take your lordships to the individual provisions of the statute before I conclude my submissions. Section 2, my lord. Section 2, as I've already submitted, it endeavors to create more transparency, where the power has been, which was under the rules vested in the Chief Justice, has now been...
Or you can call it a sharing of the burden.
Sharing of the burden.
It's a huge burden.
Yes.
Why think of it negatively? Think of it positively.
My lord,
I don't want this burden. I want to share it with my colleagues. So what?
Fantastic, my lord. That ends the matter as far as section...
Absolutely.
Absolutely. Absolutely. And because what it does is...
I don't trust them. That's the only other way. I can't trust them.
It is in this time when we want the justice system to be more efficient. It actually helps when there are more minds sitting together trying to work out how to make things more efficient and transparent in order to aid the litigants who come before your lordships, and if I may say so, the primary duty and obligation of this court is under Article 185, exercising appellate jurisdiction. 184.3 is rare cases which come before your lordships under 184.3. It is actually the appellate jurisdiction of this court which this court is duty bound to exercise. So anything and everything which advances that objective, that constitutional objective, must be supported, must be upheld. There is no fundamental right which gets offended or violated by advancing this objective. And Section 2 endeavors to do as much.
So if that was the objective, the law would again be changed if at some stage the government or the parliament decides that no, 3 judges are not enough, let's do it by ballot. So you would amend the law accordingly?
My lord, if I may.
Or let's do it, why 3 judges, why not all 17 sitting and deciding which cases go where?
My lord, if I may respond to this.
Yes, sure.
My lord, if the pendency goes down to 20,000, absolutely there would be no occasion. But if it goes to 75,000, there might be.
Why not 10?
Zero. But this is what is being sought to be addressed.
You will attend to a matter on that thing. I don't think parliamentarians, we should disparage parliament all the time. If the situation is that there's no pendency, maybe they would have not come up with this thing. Maybe if the damage caused by various judgments was not done, they would have not come up with this thing. So parliament doesn't operate in a vacuum. It hears, the government is part of it, opposition is part of it, all these people are part of it. They think and they produce something. maybe not in the most perfect of things, but we have to, each legislation must be supported unless it's clear-cut violation of the ultra-vires of Constitution fundamental rights in 184.3. Otherwise, it can be ultra-vires of Constitution, you do a 199.
Simple. And my lord, the power remains vested in this court.
But Mr. Attorney General, suppose there is a parliament that is elected in the next general election. On your theory, would that parliament not have the power to repeal this law? Of course. Oh, you see, you are saying this is a law
if
affecting.
it repeals it, yes.
That this is a law affecting, having such a salutary effect. It is having this, that, and the other. So someone can say, "जी parliament का तो power ही नहीं है, तो ये law को repeal कर दें." या फर्ज करें अगली पार्लियामेंट आती है वो सेक्शन 2 को फारिग कर देती है, वो कहती है जी चीफ जस्टिस का पावर है वो, दैट्स गुड इनफ।
माय लॉर्ड
सकती है, आपसे पूछ रहा हूँ।
जी जी
देखिए अवान साहब मैं देखें प्लीज, मैं उनको भी रोका था और मैं आपको भी रोकूंगा। मैं कंजेक्चर्स पे नहीं जाऊंगा, मैं रियलिटी पे जाऊंगा। ये कानून आ गया, अब अगली दफा कोई केस ले आएगा हम वो वाला भी देख लेंगे। मैं ओपिनियंस कभी नहीं दूंगा। आप हमारे या तो एडवाइजरी ज्यूरिसडिक्शन इस्तेमाल कीजिए, हम ऐसे आपको ओपिनियंस नहीं देंगे। आपका काम है अपनी सरकार, अपनी गवर्नमेंट को ओपिनियन देना, हमारा काम है उसको उसकी कॉन्स्टिट्यूशनलिटी वैलिडिटी आप देखें, खत्म। हम आपके ऊपर मफरूजे नहीं डालना चाहते हैं कि क्या होगा, भाई हमें क्या पता क्या होगा, जब आएगा हम देख लेंगे बहुत सारी चीजें। आप फोकस कर लें प्लीज इस कानून पे और आगे बढ़ा लें बात को, क्योंकि हम देखिए कोर्ट आप समझ नहीं रहे हैं इसकी अहमियत। हम लोग बैठ के इधर एक कंडीशन गवर्नमेंट में बैठ रहे हैं, लोग कोई जेल में मर रहा है, किसी का केस है, मेरी तो मुझे तकलीफ हो रही है। सुबह से 57,000 है, अब हम छोड़ के जाएंगे 150 और बढ़ जाएंगे, कल 150 और बढ़, आप चला लें एक महीना केस, हमें क्या फर्क पड़ता है। फर्क इसलिए पड़ता है क्योंकि हम तनख्वाह ले रहे हैं इस गरीब अवाम से एक काम करने के लिए कि उनके केसेस का फैसला कर लें, खत्म। ये बहुत अच्छी डिबेट है, जाके हाई कोर्ट में कर लें चैलेंज, वो आ जाएगा जजमेंट नंबर 94 में, हम बड़े पूरे पावर्स के साथ बैठ के इसको देख लेंगे। आपको पता है आज बेंच बनाने का क्या इशू था, इसके बावजूद के स्टे चल रहा है। मैंने अपने 2 सीनियर कलीग से पूछा कि मैं ये करने जा रहा हूँ, 2 स्टे चल रहा है, ठीक है वो एक अलग बात है, आइन कानून पर स्टे चल रहा है, फिर भी कि बात को आगे बढ़ा के किसी खत्म कर लेना, सराह लें कानून को, ये तर्क कर दें, मगर आप अपने दलाइल दें, हम उसका सुन लेंगे और फैसला कर लेंगे। कोई इख्तिलाफ करेगा, कोई नहीं करेगा, उनकी मर्जी है, हमें आपको परसुएट करने की कोई जरूरत नहीं। आप हमें परसुएट कर लीजिए और सवाल का जवाब नहीं देना चाहते मत दीजिए, हम आपके खिलाफ कर लेंगे फैसला।
My lord, my learned friend is recording the questions.
No, sorry. I'm not indulging in conjectures.
My lord,
I'm asking you a question in order to understand the principles that you are saying and arguing and submitting before the court.
my lord,
I'm not engaging in theoretical argument.
my lord.
I'm trying to understand the basis on which you are defending the constitutionality of this law.
आपका सवाल।
So therefore my question stands. Tomorrow if Parliament were to make this a law and say, let it go back to the Chief Justice in his sole capacity, would that is within Parliament's competence?
My lord, if that is so,
Learned
if it so happens.
Question.
Yes,
Learned
no,
not
Attorney
conjecture.
General.
This is to
Learned
establish the
Attorney
principle.
General.
You accept
Learned
that?
Attorney
Absolutely,
General.
my lord. Absolutely.
Learned
It is in
Attorney
Parliament's competence, and if I may say so, my lord. My lord, I have
provided assistance.
I have you know,
Your
as
answer is
Attorney General.
absolutely.
Ji, absolutely.
Yes.
Yes.
Mr. AG, to your right. In Section 2, it's provided that the bench, constitution of the bench, suppose bench is constituted, who will assign the cases to the benches? Still this power has not been given in the act. Again, there will be...
My lord, the committee is to determine its procedure, and then it, with regards how the meetings are to be, this committee itself.
Who will assign the cases that this case will be fixed before this bench? And one thing more, if 2 members, senior members comes to the conclusion, say tomorrow the Chief Justice will sit in Quetta Registry for 1 month, for 6 months, or for 1 year. Is it possible?
My lord,
what would we do if this situation occurs?
My lord, the committee has to, under subsection 2, after the commencement of this act, the committee had to hold its first meeting for the purposes of determining its procedure, and which would have included when and how where and how the meetings were to be held, and the constitution of benches, etc. But that never happened, because the law was suspended, or well, the bill was suspended before it became an act, which was also, if I may say so with regret, was a first. My Lord, this is exactly what under subsection 2 the committee is to do as the first.
So we will regulate through rules. They will regulate this act through rules.
My Lord, the committee will determine its procedure the way the Supreme Judicial Council's procedure has also been made. It's not necessarily, I don't know what their relevance, what their status is, an SRO, as a rule, or whatever they call it, but the committee can determine its procedure, and it will be a procedure of the committee for the purpose of its functioning. Now, Section 3, my Lord. Section 3 is exercise of original jurisdiction by the Supreme Court. Now, there was a question which was raised and which was asked when the petitioners were arguing that the committee is to first see whether the matter is, it has to come before the committee to examine if there is a question of public importance with reference to enforcement of fundamental rights, and if the committee thinks so, only then it will constitute a bench. And there was a question raised from the bench that would this not be an administrative power controlling a judicial function? And my response to that, my lords, is that if it is determined, it is held that it is an administrative function and it cannot be performed in a manner to control judicial powers, then my lords would surely come to the conclusion that this court will never exercise suo motu powers either, because while exercising suo motu powers, it is either previously it was the Chief Justice who would then first determine whether the matter was of public importance and relatable to enforcement of fundamental rights, and then constitute a bench. This is this tension which my lord had also while authoring judgment, rendering judgment.
This doesn't answer the question whether the threshold of 184(3) is to be decided by the committee, as this law suggests, or whether it is the function of the court, whether it's a judicial power. That's the fundamental question, that is this not a judicial power? Because there is a threshold, you say so yourself that there's a threshold. So how can a committee be deciding it? And again, it goes to the fact that if the committee decides that this doesn't meet the threshold, then the person that has filed the petition, they can't challenge that decision?
My question is, there's a distinction between what is filed under 184 and the suo motu, and that's why, my lord.
My question is, if the Chief Justice, just one person, as a master of the roster, could decide whether to take a suo motu or not, why not a committee?
Yes, and that is why my response was that
further if providing guarantees, and my only question is, are we not accountable to the litigants?
Absolutely.
The Parliament is the representative of the litigants. If they want to change our procedure because they are not satisfied with our internal or institutional independence, that's their prerogative. And we are there to serve the litigants.
And if I may, my lord.
Normally, you see, the cases would be marked by the Chief Justice, even if it's a 184(3). So I think the question of judicial power is secondary. First comes the constitution of the bench, and then judicial power is going to be exercised. Here we're talking about the constitution of the bench. It doesn't impair any judicial power. The question is, earlier the Chief Justice would mark the case to somebody. He would certainly mark it himself. I mean, I as a judge would not hear any case unless it's marked to me. And then all it says is that instead of the Chief Justice, the committee marks it.
Section
The
3,
judicial
my
power
lord.
is not in any way impeded, because judicial power comes after the bench.
Section 3 talks about invoking of jurisdiction, and that is what I was addressing.
Specifically states that the committee would examine. Yeah, देखिए the word used is examine.
And that's what I was addressing.
After for examination, if the committee is of the view that a question of public.
This is exactly
so
what
it's a judicial power.
Yes. So मैं
So
यही
how
कह रहा
can
हूँ.
the committee on the administrative side exercise judicial power?
मैं यही आपको कह रहा हूँ कि if you are minded to hold कि ये जो overlap हो गया है कि administrative function और judicial function को control कर रहा है, you would have to inevitably hold that going forward there will never be a suo motu exercise of powers, because that's exactly what the Chief Justice used to do. They will first examine it and then constitute a bench. और यही वो tension थी जो आप paragraph 53
Please take one question from this side, AG sir.
Oh, sorry.
The article 184 begins with the word Supreme Court. What does that mean? Supreme Court means all the judges or only the Chief Justice?
It's what Article 176, your ladyship says, is the Chief Justice and the judges of the Supreme Court.
184 I'm talking about.
तो 184 में जो सुप्रीम कोर्ट है, सुप्रीम कोर्ट को डेफिनेशन जो है वो 176 से फ्लो करेगी.
जी जी.
176 में सुप्रीम कोर्ट का मतलब है चीफ जस्टिस एंड ऑल द जजेस.
All the judges.
No single person is the Supreme Court. It's all of you who are the Supreme Court. So while exercising jurisdiction, अब ये हो सकता है कि आप ये कहें कि नहीं, ये सेक्शन 3 जो है ये इस तरह से नहीं होगा, इसको हम रीड डाउन करेंगे और कोई भी एक्सरसाइज सारी कोर्ट बैठेगी और वो पहले देखेंगे कि ये थ्रेशोल्ड मीट होता है या नहीं होता है, and then
you mean to say that
committee that could be an fair outcome.
Mr. Attorney General, the committee is constituted of 3 members to see whether the case do fall within the ambit of 184(3) or not. The litigant would be invited to argue, or that could be only seen by the members of the committee themselves. If 2 out of 3 comes to the conclusion that it is not a case fit for to proceed with under Article 184(3), would it not be defiance of right of audience and the Article 10A and all other due process?
In continuation, and what remedy would be available to him, because this is an administrative order, they cannot be challenged in appeal except the chamber appeal under the rules.
Mr. Attorney General, Section 3 is not actually saying that he's going to dismiss the petition at the administrative side. It is simply saying we look at the petition as the Chief Justice looks at the petition. He looks at it, it says a 184(3) petition, he marks it to a bench. It is not saying there is no consequence. Suppose he thinks there is no question, he'll mark it to some other bench. It doesn't say he'll dismiss the petition as to give a hearing to anybody. It is just to look at the
file. My lord, ये जो threshold है, administrative side पे day in day out basis पे हमें cross करना पड़ता है litigants on this side. जहाँ पे objection आ जाते हैं registrar के कि ये meet नहीं करता.
I'll tell you what's been happening. Number of 184(3) petitions have come up where the office has put objections. Yes. Not the judge, the office.
Yes.
जी one very low.
बिल्कुल.
ठीक है, उन्होंने objection लगा दी, does not come within a parameter.
chamber appeal में जाना पड़ता है.
They've come to me, some of the absolutely ridiculous kind of petitions. They're dismissed in my chamber against an appeal is filed. The fact that you don't make available 184(3) does not mean you can't file a civil suit, does not mean you can't file an FIR, does not mean you can't go to 199, does not mean any other remedy. So this is done every day, we do it. Not 3 judges, 1 assistant registrar in the branch office says not maintainable, उसके खिलाफ अपील आती है. वो कितने लोग सुनते हैं? 1 जज. उसके खिलाफ क्या अपील है? कुछ भी नहीं है. End of story. ठीक है, तो यहाँ तो बल्कि वो भी जुरिडिक्शन बढ़ गया है. वो आपने हमें वो असिस्टेंट रजिस्ट्रार के पास हमें दे दिए हैं, उसके पास होना चाहिए असिस्टेंट रजिस्ट्रार के पास, तो रहने दें उसके पास, वो बेशक बेहतर तयन कर लेगा, जो खुश नहीं होगा वो अपील में होगा. अब तो ये तो बल्कि ज्यादा उसको अहमियत दी जा रही है, रादर देन उसको निगेट कर रहे हैं. और राइट तो नहीं है 184(3) का, राइट आपके सारे महफूज हैं, जो आइन देता है, जो कानून देता है. ये नहीं कि आपने 184(3) की पिटिशन डिसमिस कर दी तो 199 में आप नहीं जा सकते हैं, या आप सूट नहीं फाइल कर सकते हैं, जो भी चीज़. यहाँ तो लोग अजीब अजीब चीज़ें, जी मेरा इससे पैसे उधार हैं, वो जाके 184 डाल दिया उसने, हमने उसको डिसमिस कर दी. रजिस्ट्रार ने राइटली मेंटेनेबिलिटी भी किया, अपील है, हमने उसको डिसमिस कर दिया, इवन दो जस्ट वेस्टेड अननेसेसरी टाइम ऑफ अ जज ऑफ द एंटायर स्ट्रक्चर ऑफ द सुप्रीम कोर्ट. So I don't know what are we taking away? Back to the same question, what are we taking away?
इसमें इस वक्त क्या सिस्टम चल रहा है? 184(3) में सिस्टम क्या चल रहा है?
2 सिस्टम्स हैं. एक है कि जब कोई पिटिशन आती है, जब कोई पिटिशन फाइल होती है तो वो ऑफिस के इससे होके जाती है. रजिस्ट्रार ऑफिस वुड फर्स्ट एग्जामिन वेदर इट मीट्स द थ्रेशोल्ड और नॉट. इनफैक्ट उसके ऊपर जो ऑब्जेक्शंस आते हैं वो कहते हैं कि जी ये नहीं मीट करता, एंड दैट्स द एंड ऑफ द मैटर. यू फाइल अ appeal. So that is one route. The 184(3) का दूसरा है suo motu. Now, this provision, in fact, cures the problems in the process on both counts. First, 184(3) की जो registrar ये power exercise कर रहा था, that power has now been given to this committee. the three senior most, Chief Justice and two senior most judges.
You see, the power of registrar could be appealed in chamber, but in 3 members committee, where the appeal lies.
Which is the 3 judges, my lord.
3 judges.
ये बात ठीक है कि उसमें ये बात हो सकती है कि जी उसकी कोई आपको जो है वो फिर आगे हेयरिंग नहीं होगी, हेयरिंग नहीं होगी, मगर
जी साहब आप ये बता देना कि अगर 2 जजेस या 3 जजेस बेंच चल रहा है, जैसे कि पुराना सिस्टम है, उसमें ये कि अगर 3 मेंबर समझते हैं कि दिस इज केस ऑफ पब्लिक इंपॉर्टेंस, वो रेफर करते हैं ऑनरेबल चीफ जस्टिस को, और जस्टिस इनकार कर जाता कि तीनों से एग्री नहीं करता. He has all the power, more power than 3 judges sitting in the court. The Chief Justice alone, sitting in a chamber, can undo this.
And the suo motu particularly, उसमें तो और ज़्यादा फिर problematic है, because उसमें तो खुद ही कर रहे हैं, वो खुद ही examine कर रहे हैं.
3 में भी the process is that if the committee thinks that it's a matter of 184(3), they'll mark it to a bench which is not less than 3. If they think it's not, they'll send it to a 2-member bench maybe, or whatever, wherever. It's not throwing out the list.
And my lord, as my lord the Chief Justice has just observed, it is not that other than 184(3), the constitution of this country or the laws of this country do not provide any remedy.
May I add to this?
My lord.
All that the committee will be doing, raising an objection.
Yes.
Objection to the effect, and that is for us internally to provide an appeal against that.
My lords can suitably amend the rules and
see, again, the question is that since 1980 had not amended our rules, that is why the Parliament was forced to amend them. Had we amended them ourselves, because the bars were raising questions, the public was raising questions, the litigants were raising questions, we actually forced the Parliament to do it for us. And everyone, there's consensus that this is exactly, अब इस वक्त हम सिर्फ ये कह रहे हैं कि बहुत अच्छा काम है, Parliament ना करती, आप कर लेते. But what when we are refusing to do that? And that is exactly what has happened.
Being 43 years.
This act simply says that we've not been doing our job earlier.
That is it.
And it's saying we'll do it for you because you've been sleeping all these years.
You were too polite to say that.
My lord, we have section 4.
I've read that.
Section 5.
अभी तक जवाब नहीं आया.
जी, वो आपने जो बात कही कि जी अब फुल कोर्ट अगर बैठेगी तो उसमें उस राइट ऑफ अपील का क्या होगा?
पहले क्वेश्चन तो ये है कि राइट ऑफ अपील कॉन्स्टिट्यूशनल अमेंडमेंट के बगैर कैसे आ सकती है जब 184(3) is a constitutional provision and it specifically it does not provide a right of appeal. Where the right of appeal was sought to be provided, it was provided specifically in the Constitution. So aren't you adding to the Constitution or amending the Constitution without an amendment
Mr. Attorney General, entry 55 says that we'll enhance your jurisdiction through an एक और 84 की appeal बना दी है. तो
185 की भी फिर एक और अपील बन सकती है.
बन सकती है. सेकंड अपील तो है, हमें वैसे भी बताया हुआ हमने कि
Speaking for myself, Learned Attorney General, speaking for myself.
Why not then a third appeal or a fourth appeal or a fifth appeal?
Obviously, it's the Parliament. Parliament won't do absurd things, and of course,
it's not a question of absurdity because this undercuts the review, the whole concept of review. The finality of judgments for res judicata is regarded as one of the most fundamental principles of the administration of justice.
It surely does.
Exception. No, अगर आप बात कर रहे हैं तो ये तो फिर infinity हो गया ना?
नहीं, infinity नहीं है. Obviously, you know, we're talking about the Parliament here. We're not talking about.
आप बात फिर आ जाती है conjecture और theory और ये और वो बात principle की हो रही है, असूल समझने की है ना. एक दफा एक बात को concede कर दिया जाए, accept कर लिया जाए, in principle then there is no limit. And therefore, if there is no limit, the question to my mind arises that therefore the power does not exist. This is the point.
Respect.
Again, a review jurisdiction भी है ना. अब review jurisdiction का क्या concept है कि Supreme Court में finality हो गई. अब आप maximum में review करने.
With great respect, when it comes to even on this plane, and even on this plane, and I submit that entry 55 sufficiently covers section 5.
Can you go to the next point?
I'll only add to this, learned Attorney General, there's a distinction. Article 185 explicitly is for those judgments that are rendered by the lower courts. Here the appeal has been provided in 184.3, which is our original jurisdiction. And it's only of a supplemental nature. It's a continuation of the same proceedings, the original jurisdiction.
And,
so I don't see how...
And in a context where this court becomes the first and the final court in the same proceedings.
That's done? Are you done?
My Lord, to this extent, and I'm just going to conclude my other two submissions here. I have placed on with my paper book the judgments of in Baz Mohammed Kakad case and the Punjab Provincial Cooperatives case. They are in volume 2, my Lord. My Lord, section 6 now, right to...
there was one concern also expressed by Justice Aisha Malik, which was that if we follow this procedure, then when the full court meets, then the appeal goes away. एक ये भी point था, इसको आप कैसे address करेंगे? Because I mean, one answer could be कि if the wisdom of all is such है, तो फिर वो naturally सब लोगों ने सारे एंगल देखे होंगे. आप कैसे address करना चाहते हैं?
उसमें एक ये बात है, मैंने अपने written submissions में ये कहा है कि आप इसको to that extent read down कर लेंगे.
इस हद तक read down करें?
जहाँ पे full court होगी, naturally appeal जो है वो literate हो जाएगा. But आप उसको ये कर सकते हैं, sorry sir. Just
I'm saying if you harmonize 4 and 5 in a situation where the whole full court is hearing it, the question of appeal does not arise.
My Lord, ये अब 15 बैठे हुए, so मैं just say, so if it was in original proceedings, it was a bench comprising of 7 lordships on this side, the appeal would have come before the remainder 8 judges, because it had to be a bench larger than the bench hearing the original appeal. In this case, we are before your lordships in original jurisdiction, full court.
इसमें ये जरूरी नहीं है कि one jumps from 5-member to full court. फर्ज करें अभी 15 जज हैं, ठीक है ना? फर्ज करें एक आर्टिकल 184(3) की जजमेंट वो पिटीशन आ जाती है, 9-member बेंच बन जाता है. फुल कोर्ट तो नहीं है.
My Lord would be mindful of
बात सुन. अब ये हो सकता है आप कहते हैं यहाँ पे जी वो चीफ जस्टिस मास्टर ऑफ द रोस्टर है, तो ये खराब और वो खराब और ये खराब. फर्ज करें 3-member कमेटी कहती है जी हम भी उसमें बैठ सकते हैं, हम राइट ऑफ अपील खत्म कर देते हैं, हम 9-member बेंच बना देते हैं. आप देखिए ना, आप इसको एड्रेस कीजिए ना. ये ऐसी बात नहीं है कि जी द विजडम ऑफ द फुल कोर्ट आ गई तो राइट ऑफ अपील तो खत्म हो गया.
What I'm submitting is that now it's a duty cast हो गई है इस कमेटी के ऊपर.
पर उसी तरह ड्यूटी पहले चीफ जस्टिस पर भी थी ना. नाउ यू पुटिंग द ड्यूटी ऑन द फुल कोर्ट, तो कोर्ट तो फिर अपनी मर्जी पर ही चल रही है ना. व्हेनेवर इट वांट्स टू डू समथिंग, वो राइट ब्लॉक करना चाहेगी. What you are saying is that substantive right that you have created under the statute is again left to the mercy of the court. It will decide कि ये substantive right देनी है कि नहीं. तो फिर आपने ये right दी किस मकसद के लिए?
8-member bench बन जाए, 9-member bench बन जाए, right of appeal खत्म हो गया.
So let me just.
I think what we can do is we can logically interpret the legislation. Now, for instance, when this case was first being heard, it was an 8-member bench. There were not enough judges, still aren't, to have heard an appeal, theoretically speaking.
Yes.
So, unless the bench, the very first day it sat, it decided to strike out this law, that's a different thing. But if it was sustainable, then how could an 8-member bench be constituted to begin with? Because that right of appeal was taken away from day one the bench sat. We are now worried about the right of appeal when there is a full court, but this question should have been raised against those, or when the bench was being constituted, that the law provides for a right of appeal. Here we are 8 of them, there aren't 9 of us available. So how that right of appeal has already gone away. We have decided an important component of this law. Before sitting in the courtroom, we have decided it. Is that correct?
Yes.
So when we are concerned now, we should have been concerned earlier too. So वो तो गई.
Actually जब वो CMAs थी full court के लिए जब आर्ग्यू हो रही थी तो उस वक्त ये सवाल बकायदा उठाया गया कि आप कह रहे हैं फुल कोर्ट बनाई जाए, आपको तो कहना ही नहीं चाहिए कि फुल कोर्ट बनाई जाए, आपको तो कहना चाहिए दिस मैटर शुड बी हर्ड बाय लेसर नंबर. वो CMAs क्योंकि वो हेयरिंग पे नहीं गई,
but the burden at the end of the day was on us.
The question was in fact put by me, and so therefore it's not that the question was not there.
My Lord, if I may briefly respond to it, followed by a response in writing.
Let me add to this. Let me add. मेरे ख्याल से जो मैं गदर कर चुका हूँ और ऑर्डरशिप पढ़ने के बाद महसूस तो ये हो रहा है कि जब ये पिटीशन ली गई उस वक्त तो यकीनन बिल था, इट वाज नॉट थ्रू द पार्लियामेंट, एक्ट नहीं बना था, बनने से पहले सस्पेंड होता जो कि आज तक इनफील्ड नहीं है. अगर ये इनफील्ड होता तो शायद 8 मेंबर बेंच उस वक्त भी ना बनता. इसका मतलब ये कि हम एक्ट को मान रहे हैं. अगर हम बेंच पे एतराज़ कर रहे हैं इसका मतलब हम एक्ट को मान रहे हैं, और अगर एक्ट सस्पेंड है फिर तो अगर 8 मेंबर बन सकते व्हाई नॉट फुल कोर्ट.
So मैं इसका brief एक response दूँ and then followed by a detailed response in writing, briefly put, and that would perhaps address ladyship's question as well, but in subject to what we have to submit in writing. Going forward, if this act is upheld and is declared intra vires, the committee at all times would be mindful that there is a right of appeal, a substantive right, which will get obliterated if a bench beyond a certain number, given the numerical strength of the court at a particular time, is constituted. So therefore, that power, that administrative power exercised by the bench.
Mr. Attorney General, इसका मतलब है पार्लियामेंट ने फैसला कर लिया कि जी फुल कोर्ट, सुप्रीम कोर्ट की फुल कोर्ट कभी बैठ ही नहीं सकती.
In cases, in circumstances में ये हो सकता है, जैसे अभी भी है.
तो सोचिए आपकी बात की कि यही प्रिसाइसली सवाल है कि इस लॉ की इस सेक्शन की वजह से.
So let me put it differently.
Now फुल कोर्ट कभी बैठ ही नहीं सकती.
नहीं, फुल कोर्ट आप बैठेंगे.
In Article 184, questions which are the most important question that can ever be raised before the court.
In exceptional circumstances, it might be so. But does that is that enough to just take away the right of appeal?
Attorney General, the other way to look at it is that if the committee were to the view that the matter is so grave and so serious that a larger bench which will not provide for an appeal be made, either full court or any large bench, then that be so. I mean, that is how the committee will decide, looking at the issue. So it doesn't take away the power to constitute a larger bench or a full court, but at the same time, it will be saying that it's so important that a collective wisdom will prevail. So there is no, I mean, doesn't really, it can be easily
It can be reconciled.
It can
My
be
Lord,
read
Section
down.
6, right to appoint.
Section 5 can be read down.
My Lord, to that extent, my Lords can hold that in exceptional cases and when a situation of this sort arises, that be so.
Right of appeal पे substantive right नहीं है जो statute.
Ladyship, look, we are faced with a situation here, and let me just be very candid now. We have had recording, we have had car case, and we have God knows what not, and all of that has happened under 184(3). With great respect, with great respect. And steel mill is a classic example. Steel mill was in profits at the time when all of that happened, as far as my information goes. It had 12 billion worth of raw material lying there. And now we are faced with an asset which is constantly bleeding.
How many of those were full court? How many of those were full court judgments?
My Lord, may not be.
यही तो मैं आपसे कह रहा हूँ ना.
Not be. मैं ये कह रहा हूँ कि इसको reconcile किया जा सकता है.
साहब यही तो point है कि एक तरफ आप कह रहे हैं हम right of appeal दे रहे हैं in order to address precisely these kind of things. दूसरी तरफ कह रहे हैं चलो full court बन जाए तो बन जाए.
Full court बन जाए, मैं ये कह रहा हूँ कि there might be issues in time.
आप kindly जरा थोड़ी सी.
नहीं, मैं there might be issues in time.
Applications of your submission तो kindly देखिए.
मैं उसको ये इस तरह से आपको कर देता हूँ कि आप
Attorney General साहब, let's be, we are all grown ups, right?
Attorney General साहब,
can I just, the problem arose, I think thousands of articles have been written, lawyers have spoken about it. We keep talking about the two chariots, but let's place some emphasis on the lawyers also say there has been allegations, and I can deny it, but it doesn't. Public opinion thinks that 184.3 has been misused, jurisdiction has been exceeded. Okay? So what you are saying is, first of all, we did not create the mess. You created the mess. We are trying to solve your mess. What did we do? 3-member bench judgment, 184.3, final judgment. Nothing can be done. Now we are concerned about full courts only. What about the 3-member bench judgment? It was a 3-member bench judgment which did Recudic. It was not a full court or even a large bench. A 3-member bench is the normal, smallest bench in the Supreme Court. So what could you do? Nothing. Now you come in advisory jurisdiction. We have to kind of find ways and means because it's the interest of the country at stake. I would rather surrender my high status and place it at the feet of the taxpayer public of Pakistan rather than give them a whopping liability of $6.5 billion because the independence of the judiciary. They'll say, what are you talking about independence of judiciary? Independence of Pakistan will disappear if you labor this much of debt on Pakistan, 6.5 billion. It's not easy. We don't understand the repercussion of things. Fine. I'm not saying that judges who decided that, they did what they thought at the time, how they were assisted according to their conscience correctly in their minds. Yes, but we make mistakes. Suppose I was a member of this bench. I would love this thing if it came to my mind, repercussions. Okay, now there's a right of appeal. I can undo. Review jurisdiction, you know what the review jurisdiction is. Take the case of Zulfikar Ali Bhutto.
Yes.
Supreme Court split. Review unanimous because the scope of review is very different creature. It is error floating on the record, so they didn't even go there. That could not be rectified through review. You had to create 184.3. If आपको simple बोलना चाहिए, अगर आप अपने इतने ज़्यादा काम ना करें, थोड़े हदूद में रहें, शायद हमें इस legislation की भी ज़रूरत नहीं पड़ती. हमने भी तो थोड़ी गलतियां कर ली. हमें देखिए हमारा problem ये हो गया ना, अन्ना बहुत बड़ी बन गई है और तकब्बुर. हमसे गलतियां हुई हैं, मुझसे गलतियां हुई हैं. मान लें गलतियां हुई हैं, ठीक है. हमने ऐसी चीजें की हैं, हमने जस्टिफाई किए मिलिट्री टेक ओवर्स को. मान ले गलती की है, ठीक है. अदरवाइज आइन की कोई हैसियत नहीं है. अगर जज में लॉ हम उसको रख लेंगे अपने ऊपर, तो वो तो फिर आइन तो गया, फिर वो तो सारे जजेस थे, उन्होंने सबने एंडोर्स कर दिया. मैं नहीं मानूंगा इसको क्योंकि मैंने हल्फ नहीं उठाया है. द मिनट आई से दैट, प्लीज फाइल अ रेफरेंस अगेंस्ट मी दैट आई एम वायलेटिंग माय ओथ ऑफ ऑफिस इफ आई से इवन दिस कि आई विल एंडोर्स दीज सब्सिक्वेंट एक्ट्स. मुल्क का भी तो सोचना चाहिए. हमें अपनी सिर्फ अपनी अना और आपको अना और इन ख्वाजा साहब मुझे नहीं पता उनको क्या मसला हो रहा है, उनको हमारा फिगर पड़िए. हम स्यूमोटो हर जगह करते हैं, हमने यहाँ क्यों नहीं स्यूमोटो किया? Why are we waiting for him to bring an act? 10 पिटिशंस आ गई, पब्लिक में से तो कोई नहीं आ रहा है. पता क्या मसला है लोगों का? उनके तो कोई मसले नहीं. वो कहते हैं हमारा केस चला के खत्म कर लें. Sorry, I'm diverging, but we have to see the larger picture also. We have to see work within the constitution where every citizen gets his due. What are we doing? What are we taking away from him? Focus on that.
Nothing, my lord.
And
Section 6, my lord.
इसमें अटॉर्नी जनरल साहब लॉ रिफॉर्म्स ऑर्डिनेंस के तहत देयर इज अ राइट ऑफ अपील. लेकिन कई केसेस में डिपेंडिंग ऑन द इश्यूज द हाई कोर्ट्स कॉन्स्टिट्यूट लार्जर बेंचेस एंड देयरफॉर दैट राइट ऑफ अपील इज नॉट अवेल. लेकिन जहाँ तक देखें ना, जो अभी बात हुई है 184.3 इज डिस्क्रेशनरी. नाउ यहाँ पे जितनी बात हुई है, even the petitioners, their counsels, they all agree that this law is in the interest of the litigants. It actually enhances access to justice. So why shouldn't we just not exercise our jurisdiction? Because in exercising jurisdiction, we will be going against the interests of the litigants. Why should we go against the rights of the litigants? It is in their interest and in their favor.
एक प्रॉब्लम अभी जो अपील के बारे में बात हो रही है, कॉन्स्टिट्यूशन हैज आंसर टू इट. सपोज आज हम 15 बैठे हैं, कल 2 वैकेंसीज है वो भी फिलअप होती है, 17 के 17 बैठते हैं. इशू यहाँ पे ये कि अपील की रेमेडी नहीं हो, इस एक्ट के तहत अवेलेबल नहीं हो. लेकिन कॉन्स्टिट्यूशन कहता है आर्टिकल 181 में, जब ऐसी सिचुएशन आ जाए तो a judge from the High Court can be asked to act temporarily as judge of the Supreme Court. तो वो आपका एक्ट कहता है कि larger bench will hear the appeal. So add one judge. This is larger bench. Appeal is there. No problem. I think problem is solved by the Constitution.
The remaining judges would be the same.
Yes, of course.
फैसला तो वही आएगा.
This will just like review.
आपने conclude कर लिए.
My lord, I just now the section, as far as section 7 is concerned, I've already submitted. I think this provision surely addresses the concerns of the litigants, fixation of cases under section 7.
Provision of intra-court appeal, that is to be seen. Intra-court appeal जो आपकी है, उसको देखना है.
इधर सिर्फ प्रॉब्लम ये जो आपने रिट्रोस्पेक्टिविटी दी है इस लॉ को, उससे हमारी पेंडेंसी और ज्यादा नहीं हो जाएगी.
My lord, at one end, now my lord would have to see
हम सारी बात चलें ठीक है मान लेते हैं जी, आप इंटरेस्ट कर रहे हैं, उधर आप उसको रिट्रोस्पेक्टिव, अब आप सोचिए 185(3) का और आप इस तारीख से दे रहे हैं, you going back up, what do you expect us to do then? The whole will be gutted.
How many cases would there be, my lord?
And no limitation period is here.
ये तो आप ना करें ना.
My lord,
ये थोड़ा
I
सा
think what has been what the parliament has,
चलो ठीक
my
है.
lord, what the parliament has tried to address here is.
You see, it is very open-ended. Prior to the commencement of this act, so it will go to 1947 or what?
जितने 185, 73 से शुरू हो जाएंगे.
My lord, 1947 तो नहीं, 75 पे पहला हुआ था.
एक बात है, अब इसमें there is open-ended ना.
And then
You have fixed a limitation of 30 days for filing appeal prior to commencement of this act. Means all previous decisions, all persons can come to this court within 30 days after the sustaining the.
I think 30 days have expired. I don't know how many came actually.
ये बताइए अटॉर्नी जनरल साहब,
जरा ये मालूम करें दफ्तर से कि इस इनएक्टमेंट के बाद अपील कितनी फाइल हुई है इस प्रोविजन के तहत?
वैसे नहीं हुई होंगी because the law was
सस्पेंडेड. ओके
couldn't have taken effect.
फिर एक और छूट जाएगा ना.
ये बताइए जितनी दफा इस कोर्ट ने मार्शल लॉज को और डिक्टेटर्स को वैलिडेट किया है, कैन द पीपल ऑफ दिस कंट्री फाइल अपील्स एंड have those judgments annulled? Why not?
I would hope so.
I think this is our accountability. Let us be open about it. Why do we fear if it's...
Otherwise we'll be brushing things under the mat.
1975, Manzoor Alai was the first case under 184(3) and thereafter, after 13 years, it was Benazir Bhutto case, 1988. ज़्यादा जो jurisdiction exercise हुई है वो perhaps पिछले 15 साल में हुई है.
Where do you draw the line? I mean, the question is, if there is transparency, then let it be. Why brush something under the mat and look into some? Why?
My lord,
let's undo Federal Shariat Court Maulvi Tamizuddin Khan case. Effectively, it won't mean anything, but maybe it will look good. I don't know. Because everybody's dead or whatever, long past. Gone.
My lord, I would conclude my submissions with this. I have the written submissions along with reliances. I have noted down one question जिसका detail
ये section 6 पे भी बता दीजिए, Learned Attorney General, ये जो आपका right to counsel. Yes, because it is already covered under Article 188 of the Constitution.
उसमें Order 26
power of the review.
जी, Order 26.
So you have said that the party shall have the right to appoint counsel of its own choice.
पहले जरा my lord का 188 पढ़ लें जो refer कर रहे हैं.
188 is the Supreme Court shall
पढ़ लें जरा.
have power subject to the provisions of any act of Parliament and of any rules made by the Supreme Court to review any judgment pronounced or any order made by it.
Yes.
So this power under the power of review.
Yes.
So this power under the power of review.
The council का provision rules में डाला गया है ना.
The Order 26, Rule 6. The Order 26 deals with the review. The Supreme Court rules. Rule 6 is the rule where the court.
No, I am only asking about the change of counsel. Why this provision has been created? Because the new counsel will come and he will argue the whole case as an appeal. Because you know the scope of the review. Normally, the counsel who appeared originally, he came in review and we hear him. New counsel will come with new fees and with new motivation and new energy. Then he will try
हमारा फिगर पढ़िए, हम स्यूमोटो हर जगह करते हैं, हमने यहाँ क्यों नहीं स्यूमोटो किया? Why are we waiting for him to bring an act? 10 petitions आ गई, पब्लिक में से तो कोई नहीं आ रहा है, पता क्या मसला है लोगों का? उनके तो कोई मसले नहीं, वो कहते हैं भाई हमारा केस चला के खत्म कर लें. Sorry, I'm diverging, but we have to see the larger picture also. We have to see work within the constitution where every citizen gets its due. What are we doing? What are we taking away from him? Focus on that.
Nothing, my lord.
And
Section 6, my lord.
इसमें Attorney General साहब, Law Reforms Ordinance के तहत there's a right of appeal. लेकिन कई cases में, depending on the issues, the high courts constitute larger benches, and therefore that right of appeal is not availed. लेकिन जहाँ तक देखें ना, जो अभी बात हुई है, 184(3) is discretionary. Now, यहाँ पे जितनी बात हुई है, even the petitioners, their counsels, they all agree that this law is in the interest of the litigants. It actually enhances access to justice. So why shouldn't we just not exercise our jurisdiction? Because in exercising jurisdiction, we will be going against the interests of the litigants. Why should we go against the rights of the litigants? It is in their interest and in their favor.
एक प्रॉब्लम अभी जो अपील के बारे में बात हो रही है, कॉन्स्टिट्यूशन हैज आंसर टू इट. सपोज आज हम 15 बैठे हैं, कल 2 वैकेंसीज हैं, वो भी फिलअप होती है, 17 के 17 बैठते हैं. इशू यहाँ पे ये कि अपील की रेमेडी नहीं हो, इस एक्ट के तहत अवेलेबल नहीं हो. लेकिन कॉन्स्टिट्यूशन कहता है आर्टिकल 181 में, जब ऐसी सिचुएशन आ जाए तो a judge from the High Court can be asked to act temporarily as judge of the Supreme Court. तो वो आपका एक्ट कहता है कि larger bench will hear the appeal. So add one judge. This is larger bench. Appeal is there. No.
Or rules are in aid of administration of justice, and rules bind the council and the litigants, but does not bind the court. What is your position on that? Am I bound to follow the rules of 1980? I mean, like for instance, Order 33 says I can condone delay, I can do various things. So it is there to be followed by litigants and counsel, but there may be cases of extreme injustice where we may overlook. For instance, in criminal matters, we rarely even ever dismiss things on grounds of limitation, though it is provided it has to be filed within a certain period of time, because the liberties of the subject, we haven't given a decision on it. So, but I think rules are really to show us, guide us, not to bind us.
Actually, rules acknowledge this. Order 33, Rule 6 actually says so.
That, overall
it says that the rules shall, nothing in these rules shall be deemed to limit or otherwise affect the inherent powers of the court.
At the end of the day, it's not so important, significant document.
My lord. It is practice and procedure. These are all.
और वो भी हमने Order 47 को connect कर दिया in civil proceedings, civil procedures court के साथ. So these are not, I mean, these are not like ironclad things, but we cannot, we'll see where the justice of the cause lies, and of course, it doesn't mean they're totally irrelevant, so we will see when it's appropriate. It may be a good case, it may be a bad case, I don't know. So, are you conclude या कुछ और रह गया?
My lord, I have concluded.
Attorney General, if I
in
may
writing,
ask a question, if I may ask a question.
Well,
if you are not bound by the Supreme Court rules in terms of whatever the Supreme Court rules say, but we are bound by Act of Parliament in regard to our own practice and procedure, do you think that is a constitutionally viable position?
My lord,
then if these rules are made by the full court on the administrative side, and any particular bench can say, well, goodbye to the rules, why shouldn't that bench have the right to say goodbye to the act?
My lord, my response to that would be that both the preamble, from which we draw those salient features.
I think the thing is
the independence
that when the Supreme Court is sitting as a court of law, what is it bound by? If it's not even bound by its own rules, why should it be bound by Act of Parliament?
My lord, the rules say
that particular bench can say, well, we don't recognize section, what is it, section 6, and another bench can say, well, we recognize section 6.
My lord,
I mean, why should not your this law that you are defending,
I think
that be put in the same category vis-a-vis our own rules? If we are not bound by one, why should we be bound by the other?
As I view it, I think priority number 1 is constitution. Number 2 in scale of importance is law. Number 3 is rules. Then come regulations, then come notifications, then come whatever you want to, instructions. So this is, in my mind, I go by that approach. I may be wrong.
My lord, the rules, actually Rule 6 of Order 33 itself acknowledges that.
I think the Constitution actually
abuse of process नहीं होगी, ends of justice को meet करने के लिए you're not bound by
Attorney General, the rules actually come out of the Constitution, and Constitution says the court has to be regulated. So I think that, in my opinion, certainly the rules regulate the affairs and we're bound by them. And they might be in the trajectory starting with the Constitution, law and the rules, but all of them are binding, and that's how the system works.
And my lords would also acknowledge that this is not a case where Article 199 per se has been challenged on the basis of it being violative of salient features for that matter. Of course, even if that was so, both 191 and the preamble from which the salient features flow were enacted at the same time. It is not a subsequent amendment where relying upon Kesavananda Bharti or DBA Rawalpindi matter could have proceeded. So when the preamble, when the Constitution was being made, 199 has not undergone any amendment ever since. So therefore, my lords, my respectful submission would be that this act, my lord, be declared constitutional and the petitions be rejected to that effect. And nothing in this act in any way undermines the independence of judiciary, nor has any externality been introduced where any other organ of the state or branch of government has been given any role whatsoever.
Hopefully these are your final words. Hopefully.
I'm going to answer. My lord.
आपने कंक्लूड तो कर लिया, बस एक क्वेश्चन पूछना था कि अगर फर्ज करिए कभी इसको हम अल्ट्रावायलेंस डिक्लेयर कर देते तो बात ख़त्म हो, लेकिन अगर इसको हम कहते हैं कि वैलिड लॉ है, वैलिड लॉ हो जाएगा वहाँ से जब ये बना था। इन बिटवीन जो फैसले हुए हैं, व्हाट इज द फेट ऑफ दोज डिसीजंस? अगर वैलिड करते हैं तो फ्रॉम दैट डेट होगा, तो फिर क्या होगा, इसके बारे में आप बता दें।
They become past and closed transactions in several instances in the past where a similar situation or a situation arisen where a legal position had changed, but cases were decided or transactions had happened. The courts protected those under past and closed transactions, so that would be the effective matter which should decide.
Can the committee not retrospectively, suppose if the law is sustained, can the committee not retrospectively grant permission? A bench was constituted, assumed as if by consent. Let's put it like that. I don't know if that's possible
cases
or
which
not.
stand decided, they stand decided, and that extent is past and closed.
अगर कोई बहुत ही ऐसा unusual case आ जाए, I don't know.
My lord, I don't know where the line would be drawn, but in so far as
I think
जी मैं इसको भी एड्रेस कर दूंगा।
ड्यूरिंग द पीरियड की बात हो रही है ना,
जो
इस दौरान जो हुए फैसले हो गए, उनका क्या बनेगा?
सो जो केसेस लिस्ट अब पेंडिंग नहीं है और वो डिसाइड हो गए हैं केसेस ड्यूरिंग दिस पीरियड, उसको अब आपको देखना होगा कि उसको आप पास्ट एंड क्लोज में प्रोटेक्ट करते हैं जो फैसले हो गए।
इतना पास्ट नहीं हुआ, अभी कई बात है
वो। आई थिंक दैट इज समथिंग दैट माय लॉर्ड वुड हैव टू
दो चीजें हो सकती हैं।
इफ माय लॉर्ड विश टू प्रोटेक्ट देम इन द पास्ट एंड क्लोज
all the angles. उसमें दो possibility, that is possibility. So this is a possibility. We're just airing it. We don't know the answer.
उसमें दो चीजें हो सकती हैं। एक तो डिफेक्टिव डॉक्ट्राइन को हम देख सकते हैं, दूसरा राइट ऑफ अपील प्रोवाइड हो जाएगी, सो दे कैन जिनके
as far as 184(3 is concerned उसकी होगी, जिनकी नहीं थी 184(3 वो तो सिर्फ बेंचेस की कॉन्स्टिट्यूशन तक रह जाएगी बात। उसमें आप देख सकते हैं कि वो तो
It won't be a classic, देखिए दो किस्म के होते हैं, एक होता है classic quorum non judice, ठीक है, this won't fall in that category. It will be simply a procedural lapse, whether a procedural lapse will affect the outcome.
The cases which stand
I don't know. I mean,
if I may be,
क्योंकि एक तो होता है ना substantive right किसी की गई, बोले आपका क्या right किया?
वो decide हो गए cases, वो past and close।
नहीं, past and close का लफ्ज़ क्या अगर हम कहें, देखिए एक होती है you substantive right has been taken away. भाई okay, these three didn't hear it, those three heard it. आपको क्या फर्क पड़ा इससे? Are you with me?
Ji.
So I'm just thinking aloud.
Understood. So it does not, let's say, there is no, it substantially कोई offend नहीं किया किसी right को कोई, it was a matter of procedure.
और अगर कोई जैसे कहा कि कोई बहुत ही चीज हो गई ऐसे वो रिव्यू तो पड़ा हुआ है फिर भी और ये अपील पड़ी हुई है 184 में. तो
And in any event, I mean, it was a bench comprising of your lordship.
No, we don't want to kind of create a situation where things don't function. So भाई वो उसको क्या पड़ेगा? चलिए आपने मेरा अदालत में सुन लिया या सरदार साहब की अदालत में सुन लिया. कोर्ट तो थी ना, वो तो गलत criminal justice होता है ना, गलत अदालत अब चलेगा या उसके पास इख्तियार ही नहीं था to begin with. हमारे पास इख्तियार तो था. बस सिर्फ वो एक practical procedural matter that would be really for us, not for the litigant. उसको क्या पढ़ना है?
I would say, my lord, and that I think to that extent.
I don't think that it will affect the decided cases. It has become past and close.
I think that's the only fair conclusion that we can arrive at. And so far as
we are just going to take a short break. Let Qazi Saab and others and any other from the petitioner side. I see Mr. Bandari. You are for the petitioner or the?
Your lordships had put various political parties.
No, who are you for?
I am for PTI.
Which side of the divide?
I am supporting the petitioners, but I am also not saying that Article 191 is completely outs the powers of the Parliament.
I would really like to hear you. Anyone else from this side? Petitioner. तो अगर आप लोग articulate जरा कर लें, we'll take a short break.
My lord, I have actually filed my written submissions.
नहीं, अगर why are you depriving us the pleasure of hearing you? Unless you want to deprive us, that's fine.
No, not at all, my lord. I'm here.
चौधरी साहब भी हैं. तो and of course we won't rush it. आप अपने जवाब भी दे दीजिएगा जो आप देना चाहते हैं. And we'll just come after. We just take a short. I think prayer time is also there. Short break, huh?
And if I may be granted leave, I have to.
As long as you leave somebody here who will note all the things, and then, if required, submit the. If you think, if you want to, we can't force you to submit a reply. But it may be in your interest to do so.
Mr. Attorney General, best wishes from all of us on the assignment they want. It's in the national interest, and it's very important for Pakistan. So our best wishes.
My lord,
I hope you are well prepared.
आपने 22 questions मुझसे पूछे हैं जी. You asked me.
आते हैं वापस आते हैं.
नहीं, 22 questions में you like me to ask you to answer now, or you want me to give me some time to?
नहीं, हम जरा वापस आ जाते हैं. फिर आपको कुछ सुनते हैं. अगर कोई बहुत ही पेचीदा सवाल हुआ, फिर हम देखते हैं.
पेचीदा सवाल तो सारे ही हैं.
But देखिए, petitioner always comes prepared of all the questions कि सारे आ सकते हैं. तो वो देखें, other side can say that, but you can't. You are the petitioner.
May I say something?
जी.
देखिए,
ख्वाजा साहब जरा बात समझने की कोशिश करें ना. The functioning of the Supreme Court has ground stand still. I don't want that to continue.
मुझे आप इजाजत दीजिए.
ठीक है.
मैं ये 22 सवाल जो हैं, मैं इनका जवाब लिख के आपको दे देता हूँ.
चलिए, आप हम वापस तो आते हैं. इनको तो सुनेंगे ना बंदारी साहब को. शायद आप मुतमईन हैं साहब को. तो मैं ये ऐसी जबरदस्त बात करें आप.
बंदारी साहब को जो है मेरे पास आ चुका है जी. मुझे आप इजाजत इतनी दीजिए.
देते हैं, वापस आके देते हैं. देखते सुने तो कुछ थोड़ी बात
देखना तो ये है ना कि पार्टीज क्या कहती हैं, वो पार्लियामेंट की सुप्रीमेसी चाहती हैं या नहीं चाहती.
सुनकर मौक़िफ़ हमने नहीं सुना अभी तक. थैंक यू. यू कैन गो देन लीव समवन हियर कॉम्पिटेंट. हाँ, थैंक यू.
सदर ममलिकत आरिफ अलवी साहब ने इलेक्शंस की तारीख दे दी. उसके बाद ये जो फैसला आ गया, साबिक चीफ जस्टिस उमर अता बंदयाल साहब ने नैब के हवाले से जो फैसला दिया है, फिर बिलावल भुट्टो साहब आपके ऊपर बड़ी तनकीद कर रहे हैं, और अपेरेंटली लग ये रहा है कि पीपल्स पार्टी का एक ग्रुप वो स्टैंड करता है, सदर ममलिकत के इस खत के साथ स्टैंड करता है. तो ये हो क्या रहा है मुस्लिम लीग नवाज के साथ? बिलावल साहब कह रहे हैं कि इलेक्शन कमीशन को नहीं अंदाजा इलेक्शंस कब होंगे, हमें नहीं पता इलेक्शंस कब होंगे. और एक सियासी जमात जिसमें उसने नून लीग का नाम तो उन्होंने नहीं लिया, लेकिन नून लीग को टारगेट करते हुए कह रहे हैं कि वो खुद से ही फरवरी में इलेक्शंस के हवाले से बातें करती जा रहे हैं, और लेवल प्लेइंग फील्ड भी वो कह रहे हैं कि हमें नहीं दी जा रही. तो ये क्या हो रहा है मुस्लिम लीग नवाज के साथ?
देखें, ऐलान नहीं किया. मेरा ख्याल है ये मिस इंटरप्रिटेशन है. जो भी खत लिखा है सदर अलवी ने, उसमें उन्होंने कैलकुलेट किया 48(5) के तहत कि भाई इस फलां दिन जो है ये बनता है, और आप इस दिन को मद्देनजर रख के मशवरा शुरू करें पॉलिटिकल पार्टी से भी और सुपीरियर जुडिशरी से, और जो भी ऑल कंसर्न जो है ना उनसे आप मशवरा करें. उन्होंने ये नहीं कहा कि जी ये इलेक्शन की डेट का मैं अनाउंसमेंट कर रहा हूँ। अगर आप लेटर पढ़ें खुसूसन उनका जो लास्ट पैरा है बड़ा इस चीज में बड़ा वाजे है। इस चीज के ऊपर उन्होंने इबहम जरूर क्रिएट करने की कोशिश की है, जिस तरह आपकी बात से पता लग रहा है कि देयर इज वन इंटरप्रिटेशन जिसमें कहा जा रहा है कि उन्होंने अनाउंस किया है। लेकिन अगर आप लॉयर से पूछें या किसी जो लीगल एक्सपर्ट्स, कॉन्स्टिट्यूशनल एक्सपर्ट्स है ना, he has avoided being conclusive on the subject. और उन्होंने he has actually played all sides. उसने अपनी पार्टी को भी खुश किया, देखिए जी मैंने लेटर लिखा था और मैंने ये किया था। वैसे भी एक मॉरल अथॉरिटी तो उनकी जो है वो इरोड कर गई हुई है। रीजन बीइंग के उनकी टेन्योर भी खत्म होगी। अब जब तक इलेक्शन ही ऑब्वियसली कॉन्स्टिट्यूशन अलाउ करता है कि ही कैन कंटिन्यू। उन्होंने लास्ट टाइम अपनी जो लेग है सारे प्रेसिडेंशियल टेन्योर की, उसमें एक कंफ्यूजन क्रिएट करने की कोशिश की है और उसमें उन्होंने अदलिया को भी ड्रैग करने की उसमें कोशिश की है। तो लेकिन इट इज एन अटेम्प्ट व्हिच विल फॉल फ्लैट ऑन इट्स फेस। एक बात। दूसरी बात जो है, मेरा ख्याल है कि आप इसको अगर इंटरप्रेट करेंगे तो मेरी बात से आप एग्री करेंगे कि ये कोई अनाउंसमेंट नहीं है तारीख की, और ना उनके पास इस किस्म की कोई पावर है कि वो अनाउंसमेंट करें।
और खास ये जो बिलावल भुट्टो जरदारी साहब टारगेट कर रहे हैं मुस्लिम लीग नवाज को, वो कह रहे हैं कि नून लीग अपने तय फरवरी में इलेक्शंस की बातें करती जा रही है, हमें लेवल प्लेइंग फील्ड नहीं दी जा रही। इस पर आपका क्या ख्याल है?
देखें, मैं उसकी जो निटी ग्रिटी जो है उसमें नहीं जाना चाहता, लेकिन सीसीआई के उस डिसीजन के ऊपर पीपल्स पार्टी ने भी दस्तखत किए हुए हैं। मोहतरम मुराद अली शाह साहब ने एज चीफ मिनिस्टर सिंध दस्तखत किए हुए हैं। तो वो उनका आप कहना है कुड बी इन आफ्टर थॉट, लेकिन ये जो भी स्पेकुलेशन हम कर रहे हैं कि इलेक्शन जो है फरवरी में होंगे या जनवरी में होंगे, तो उसी बेसिस पे कर रहे हैं कि इलेक्शन के जो सिलसिला है वो जब तक आप हल्के बंदियां नई जो है नहीं बनाएंगे तब तक जो है ना वो आप जो है इलेक्शन जो है ना वो नहीं करवा सकते। नई जो सेंसेस है उसके ऊपर ऑटोमेटिक बात हो जाती है। So when they were signing that or they were voting for unanimity in CCI, तो उस वक्त उनको पता था कि इसकी क्या रिप्रिकॉशंस हैं, जो कॉन्स्टिट्यूशनल लीगल रिप्रिकॉशंस क्या हैं। तो मेरा ख्याल है वो भी एक एक सियासी पोजीशन ले रहे हैं, लेकिन कॉन्स्टिट्यूशनली और लीगली जो मैं आपकी खिदमत में अर्ज कर रहा हूँ वही पोजीशन है। एक पॉलिटिकल पोजीशनिंग जो कर रहे हैं, जो उनका राइट है, आई हैव नो प्रॉब्लम विद दैट। तो प्रेसिडेंट साहब जो पोजीशन ले रहे हैं वो जो है अपनी पार्टी के साथ जो है उनके घर जाने का वक्त आया हुआ है। वो चाहते हैं कि घर जाऊं तो कोई इज्जत आबरू हो, मुझे कोई पार्टी जो है वो एक्सेप्ट करे कि जी आपने बड़ी 30 मार खान थे जब आप
हमें ज्वाइन करेंगे सेनेटर अली जफर साहब, पाकिस्तान तहरीक इंसाफ के सीनियर रहनुमा। बहुत बहुत शुक्रिया। इरफान काजी साहब, मैं आगाज में आपसे सवाल करूंगा, ये जो सदर ममलिकत डॉक्टर आरिफ अलवी साहब ने खत लिखा है चीफ इलेक्शन कमिश्नर को और उसके अंदर तजवीज़ दी है 6 नवंबर को इंतखाबात करवाने के लिए, और उन्होंने ये भी कहा है कि मुशावरत की जा सकती है सुपीरियर जुडिशरी से, कैसे देख रहे हैं आप इसको?
बिल्कुल, उन्होंने उनको गलत एडवाइस किया गया सदर पाकिस्तान को। उनके जो कानूनी मशीरान है, मेरा ख्याल है उनको पता ही नहीं है कॉन्स्टिट्यूशन की, अंडर कॉम्प्रिहेंशन ही नहीं है। पहले ये जो आउट गोइंग चीफ जस्टिस है वो गलती कर रहे थे, वो बार बार डेटें दे रहे थे इलेक्शन की, और वो भी ऑब्वियसली इलेक्शन कमीशन को जबरदस्ती तो कोई नहीं करा सकता कि भी आप इतने दिन के अंदर कर दें या सदर डेट दे दे। सदर का काम ही नहीं है डेट देना, और सदर एक सूरत में डेट